Right, let's talk about contracts. They're everywhere, kind of like the invisible rules of our daily lives. But let's be honest, most of the time they just feel like this minefield of confusing legal language, right? Well, what if you could see right through that fog? Because understanding what you're really signing up for, that's a modern-day superpower. So let's start breaking it all down. I mean, we've all been there, haven't we? You're signing up for some new service or buying something online and boom, there it is. That giant wall of text. So what do? We scroll, 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 find the little box, tick it, and click agree without a second thought. But have you ever stopped to wonder what promises were actually in that fine print? And maybe more importantly, which of them can actually be enforced? Okay, so if we're going to spot the traps hidden deep in that fine print, we first have to get a handle on the language of contracts. Because, and this is a big one, in the eyes of the law, not every single promise is created equal. So let's dig into the difference between a real, legally binding promise and, just simple sales talk. And right here, this is the first huge distinction you need to get. On one side, you've got a term. Think of this as a core promise. It's like a gear inside the engine of the contract itself. But on the other side, you have a representation. Now, that's more like the glossy brochure. It's the sales pitch, the stuff they say to get you to sign on the dotted line. Now, both are important for sure, but only one of them is a fundamental, baked-in part of the actual deal. And this is where it gets really important. When a term is broken, that's a breach of contract. Simple as that. And that comes with real legal consequences. Now, if a representation turns out to be false, yeah, you might have some legal options. But breaking a core term, that strikes right at the heart of the entire agreement. And that is why knowing the difference between these two is basically your first line of defense. All right, so we know what a binding term is now. Let's talk about the real reason people get so nervous about fine print. See, it's often where companies hide something called an exclusion clause. And this is a really powerful tool they use to try and limit their own responsibility when things inevitably go wrong. I mean, just look at this. The company accepts no liability for loss or damage howsoever caused. Wow, that is a classic, sweeping example right there. It's designed to be a complete and total shield for them. You see a sentence like this, and it's easy to think, well, I guess I have no rights at all if this thing breaks or the service is terrible. It sounds pretty final, doesn't it? So what an exclusion clause really is, it's basically a get-out-of-jail-free card that a company tries to write for itself, right into the contract. It's their attempt to just erase their legal responsibility before anything has even happened. But that brings us to the big question, the million-dollar question, really. Can they actually do that? Is that legal? Well, the answer, and this is the good news, is not always. Thankfully, the law isn't just going to sit back and let that happen. It has some really powerful safety nets in place to protect us from these wildly unfair clauses. So let's meet the two main legal heroes in this story. First up, we've got the Unfair Contract Terms Act of 1977, or UCTA for short. The easiest way to think about this one is as the law that levels the playing field between two businesses. It's there to step in and make sure some huge corporation can't just use its size and power to force a really unfair, risky deal onto a smaller company. And then we have the much more recent Consumer Rights Act from 2015. And this is your shield. This is for us, the consumers. So when you're buying a new phone, signing up for a gym, booking a flight, you name it. This is the law that has your back and makes sure the terms you're clicking agree on are actually fair. So we have these two different acts, and there's a really good reason for that. The law is smart enough to know that a giant corporation making a deal with another giant corporation is a totally different ballgame than you or me just buying a new toaster. They have to be judged by completely different standards. Okay, now this is where it gets really interesting. For those business-to-business deals, the main test the law uses is one of reasonableness. So a court would look at it and ask things like, did both sides have good lawyers? Was this a standard kind of term for this industry? But for you, the consumer, the test is much simpler and much stronger. It's a test of fairness. A court will just ask, does this term create a massive, unfair imbalance against the consumer? And get this fairness test covers all kinds of unfair terms, not just those sneaky exclusion clauses. Okay, so that's all the legal theory. But how does any of this actually help you in the real world, right? Well, let's turn all this knowledge into a simple, practical toolkit you can actually use. Here it is, a super simple 3-step checklist. Anytime you come across a clause that just feels off, just run it through these 3 questions. First, was this clause even clearly part of the contract I agreed to in the first place? Second,
Does the wording of this clause really specifically cover the exact problem I'm having right now? And third, this is the big one. Even if the answer to those is yes, is this clause actually legal? Is it reasonable if it's a business thing? Or is it fair if it's something you bought? This little framework is your absolute best first step to pushing back on a sketchy term.
So let's do a quick recap of the absolute essentials. Remember, a term is the real binding promise. Always be on the lookout for those exclusion clauses that try to take away your rights. And most important of all, never forget you have legal safety nets. UCTA for businesses, and the big one, the CRA for you. Honestly, just knowing this stuff should make that scary wall of fine print look a whole lot less intimidating. And all of this leaves us with one last big question to think about. These legal protections were created in a world of paper, pens, and handshakes. But we live in an age of one-click agreements and terms of service that can change overnight. So are these laws still strong enough to protect us? That's definitely something to chew on the next time your mouse is hovering over that I agree button.